Good afternoon and welcome once again to the UNCITRAL Working Group 3 virtual pre-intersessional meeting on the use of mediation in ISDS. That's jointly organised by the United Nations Commission on International Trade Law, UNCITRAL, the Department of Justice of the Hong Kong SAR, DOJ, and the Asian Academy of International Law, AAIL. Our third session of the day is on the topic of hybrid models for resolving international investment disputes.
A very good morning, afternoon, and evening to one and all. Thank you to the organizers, UNCITRAL and the Hong Kong Department of Justice and the Asian Academy of International Law for putting together this well-organized pre-intersessional meeting on the use of mediation in ISDS. This session commences the second part of our pre-intersessional meeting, and our panelists today will be exploring issues relating to hybrid models of arbitration and mediation against the backdrop of our earlier sessions on challenges to the use of mediation in ISDS and multi-tiered dispute resolution processes. As has been acknowledged by the panelists at the earlier two sessions, arbitration is the more common method by which investor-state disputes are pursued. Mediation is less commonly used, even though it promises time and cost savings, as well as the opportunity to design solutions and better preserve the investment relationship. So the question then arises on whether there is room for expanding the role that mediation can play in the resolution of investor-state disputes through the means of hybrid models such as MedArb, ArbMedArb, or ArbMed, which are familiar to us from the international commercial disputes context. As the background paper for this session suggests, combining mediation with arbitration in hybrid forms may increase the chances that parties mediate as the opportunity to mediate is thereby increased. Bringing mediation into the picture could also help disputing parties narrow down or crystallize the issues in their dispute. That said, issues do arise from combining adjudicator and non-adjudicator models, and which relate to, amongst others, potential implications for due process. So these, for example, are the role of the neutral or the multiple roles of the neutral in the case of performing both the functions of an arbitrator and a mediator, access to privileged information by the neutral, and access to confidential information by the other disputing party. Are these real or imagined obstacles? Can they be overcome? And what other issues could arise? Our panelists today will be tackling these questions and more during our session today. In order to facilitate the panelists transitioning seamlessly from one speaker to the next, I will introduce all our panelists right now at the start of the session, and each panelist will have 15 minutes. Our panelists will be managing their time on their own, and you will next hear from me during the Q&A segment that will follow the final panelist's presentation. As with the sessions earlier, you're invited to post your questions in the chat anytime, and we can take them up during the Q&A segment. Our panel today features 5 distinguished panelists. Mr. Basan Legum, partner and global co-chair of litigation and dispute resolution with Denton's law firm, who will introduce us to the legal issues in the use of hybrid models in ISDS. Mr. Francis Xavier, president of the Chartered Institute of Arbitrators, who will explore the use of mandatory mediation in the hybrid context. Francis will be followed by Mr. Tao Li Jun, partner with Zhonglun Law Firm, who will offer the Chinese perspective on the use of hybrid models. And next, Ms. Blanca Salas-Ferrer, legal officer with the European Commission's Directorate General of Trade, will offer the European Union's perspective on the use of mediation in the context of a multilateral investment court. Wrapping our presentations, we will have Professor Hai-Tik Shin, Emeritus Professor of Law from Seoul National University School of Law, who will take us through the issues relating to arbitrators acting as mediators. So first up, Mr. Basan Legum. Over to you, Bart.
Thank you very much. Just give me one moment to put my PowerPoint presentation on the screen. All right, as has already been said, hybrid models of dispute settlement integrate mediation with arbitration. Most of the issues presented by these models are practical ones, not legal ones. My presentation today will address three categories of legal issues: treaty text, integrity of arbitration proceedings following a mediation, and what it means for a settlement agreement to be enforced as an arbitral award. I begin with treaty text and how not to draft a provision for hybrid mediation/arbitration. You see on the screen the text of one of the early references to conciliation in an investment treaty. This is the 1984 bit between the United States and what is now the Democratic Republic of Congo. Here you can see that arbitration and conciliation are presented as alternatives. The presentation is similar in some respects to the fork in the road provision that follows this one in the bit. One possible reading of this text is that either a party can invoke arbitration or it can invoke conciliation, but it cannot do both. The ambiguity created here discourages use of conciliation. Arbitration before a neutral international forum is a material right for claimants when it is available. While many claimants might prefer to resolve their dispute through conciliation or mediation, they generally will not accept the risk of the mediation being unsuccessful if it means losing the right to go to arbitration. I've often thought that the infrequent use of conciliation in ISDS is in part a product of this drafting, even though the intent behind the provision was almost certainly to promote conciliation as an avenue for investor-state dispute settlement. So the first legal issue with hybrid models is this: if you intend to implement a hybrid model, make sure that the provision you draft makes it clear that both mediation and arbitration are available without one precluding the other. This is particularly important given the priority to arbitration. See if I can go back, there we go. The priority to arbitration under the ICSID Convention. You see on the screen Article 26 of the convention. If parties consent to ICSID arbitration, that excludes other remedies unless otherwise stated. Given this text, clarity is critical. The second set of legal issues results from key differences between mediation and arbitration. Arbitration works because of transparency between the arbitrator and the parties. There is a certain distance between them. Ex parte contacts, by which I mean separate discussions between the arbitrator and only one party concerning the case, ex parte contacts are not permitted. Each party has access to all information communicated by the other party to the arbitrator. Each party knows every detail of the case the other side has put to the arbitrator. It therefore knows the case it has to meet. It would raise serious due process issues for one party to be able separately and secretly to communicate information to the arbitrator on the issues in dispute. At the same time, each party has in arbitration the right to put its strongest case to the arbitrator. It is not required to admit or volunteer weaknesses in its case. Mediation, on the other hand, can and often does involve a different relationship between the parties and the neutral. Caucuses, by which I mean separate meetings between the mediator and one party concerning the case, are one of the strongest tools in the mediation toolkit. Caucusing works because each party knows that what it says to the mediator will remain secret unless the party expressly authorizes disclosure to the other side. Caucusing can give the mediator a perspective on how to resolve the dispute that neither party has. The mediator's role can be that of cheerleader, encouraging the parties to put aside their differences and find a common ground. It can be that of confidant and counselor, working with one party to help it frame its offer in terms that the other party might accept. It can also be that of critic, working to assist a party in recognizing the weaknesses in its position and to modify that position if it is unrealistic. Mediation and arbitration individually work well on their own terms because they are different processes. Hybrid models can work well as long as they keep the processes separate. When the processes are combined, or when confidential information disclosed in mediation leaks into the arbitration process, problems can result. These problems qualify as legal issues because arbitral awards are subject to independent legal review. This review is, as we know, limited to specific grounds. But it is fair to say that under most legal standards, whether those for annulment of awards under the ICSID Convention, set aside under national arbitration laws, or enforcement under the New York Convention, a violation of fundamental due process can render the award unenforceable or subject to annulment. While it is dangerous to generalize, it is fair to say that many reviewing courts or annulment committees would not look kindly on separate meetings between an arbitrator and a party in which matters concerning the case are discussed in secret. Now, similar issues arise with the use in arbitration proceedings of confidential communication disclosed for purposes of a mediation. You see on the screen the default approach of the ICSID Convention, which bars use of any such communications absent party agreement to the contrary. While the convention uses the term conciliation rather than mediation, the process of ICSID conciliation today is not materially different from what I would call mediation, and this is therefore a pertinent provision for hybrid ISDS. Now, it's tempting in designing a hybrid model to attempt to save some costs and time by having the same person act as both mediator and arbitrator. But the legal issues that I have identified counsel in favor of keeping the two processes separate. Compared to arbitration, mediation is not costly. The incremental cost of a separate mediator is greatly outweighed by the risk of a much more costly arbitration being for nothing because the award is annulled or unenforceable. In a thoughtful 2009 article, Professor Gabriel Kaufman-Kohler addressed the limits of what an arbitrator properly may do to facilitate settlement of a dispute. And there are indeed a number of things that an arbitrator can do without crossing the line of propriety. But caucuses are not on that side of the line, and the role of the arbitrator must remain evaluative, not facilitative. To my mind, an arbitrator that respects these lines remains an arbitrator and does not act as a mediator. Professor Kaufman-Kohler does not here address a hybrid model combining arbitration and mediation, but what an arbitrator can do to facilitate settlement while remaining an arbitrator. Now, it may also be tempting to think that these legal issues can be put aside if a treaty binding on the host state and the investor's home state provides to the contrary. And it's correct that with the right implementing legislation, a treaty can change the law in those states that are parties to it. The difficulty is that investors frequently seek enforcement in the courts of non-party states. To the extent this is important for the effectiveness of ISDS, bilateral arrangements may not be sufficient to address the legal issues that are posed. The safest course, I submit, is for different neutrals to act as mediators and arbitrators in hybrid systems, and for the system to prohibit any use in arbitration of confidential information disclosed in mediation. Now, this brings me to the final issue that I wanted to address, the usefulness of embodying a settlement agreement into an arbitration award. Converting a mediated settlement into an arbitration award is often mentioned as a benefit of a hybrid model. From my perspective, as a litigation professional, this benefit provides added value in some cases, but these are relatively few and far between. Let me explain briefly why this is. Now, both settlement agreements and awards set out obligations that are binding legally on the parties. The difference is that the obligations in awards can be enforced by the officers of courts, but not every part of the award is capable of enforcement. Only the dispositive part of the award is enforceable. This is the very last page or two of the award, just before the signatures of the arbitrators. You see on the screen an excerpt from the most recent award posted to the ICSID website. The obligation in paragraph 399 is a simple, clear, and unconditional order of payment. This can be enforced by court officers without adversary proceedings or the intervention of a judge. And there may be settlements in which it would be useful for a party to have a consent award with an order of payment such as this. However, in most settlements I have advised on, the parties would much prefer to have money in the bank. An arbitral award can only be monetized if sufficient assets are located and can be seized and sold at judicial auction. This is good, but doing this takes time, effort, and a bit of luck. Money in the bank is better. The other paragraphs you see on the screen deal with findings of non-liability and dismissal of claims. These, in an award, have res judicata effect. They preclude any further claim on the topics addressed. Again, this is a good thing, but in most cases, this is not more effective than a well-drafted release, waiver, and covenant not to sue in a settlement agreement. Moreover, many settlements include more complex provisions, such as representations, warranties, indemnities, and covenants. These provisions are not generally capable of being stated in terms that a court officer can enforce without intervention of a judge and adversary proceedings. Whether these provisions are in a settlement agreement or in an award, further litigation will be required in the event of breach. And again, the value proposition for a consent award over a settlement agreement is not obvious. The greatest benefit of consent awards is in cases where the relevant national legal system requires or expects settlement agreements to be approved by tribunals before which the dispute was pending. Here, there is a clear added value, but it is one that has more to do with authentication than with enforcement. This concludes my brief review of legal issues presented by hybrid models. I will now turn the floor to Mr. Francis Xavier to address the use of mandatory mediation in hybrid models. Thank you.
Thank you, Mr. Legum. That was very informative. I'm just going to share screen. I have presented, I have some slides. So I'm talking about mandatory mediation in ISDS. And now, first of all, I want to talk about the current landscape before I go on to the benefits. Is there a slide before this? Right. And so the current landscape, let me just say a few words before I go to this first slide. The current landscape is that, jurists have noted that out of 2,577 IAAs, international investment agreements that have been mapped by UNCTAD as of March 2020, 627 treaties contain voluntary ADR provisions. None contain mandatory ADR provisions. Only 1% of the IAAs mapped globally even mention mediation. And in another study by Anna Ubilava, over 3,000 IAAs worldwide were surveyed. As at September 2020, there are only 2 recent treaties entered into in 2019 that makes conciliation a mandatory precondition to arbitration. The Hong Kong UAE BIT and the Indonesia-Australia Comprehensive Economic Partnership Agreement. So really, when you talk about mandatory mediation, that's hardly on the scene at the moment. Now, mandatory mediation, as you know, is a feature of modern international commercial arbitration. And in a 2019 Queen Mary study, most of you would be aware of it, 64% of the respondents favored the use of mandatory mediation in treaty disputes. And obviously, this is on the rise because you will see, for instance, in the 2016 model BIT produced by India, there is a provision for a mandatory consultation, an effort at mediation. Now, first of all, I want to talk about the many advantages of mediation in an ISDS context. And I'll go through this quickly because many of you would be familiar with it. The preservation of the relationship, which would be a key relationship central to nation building. The array of settlement options available to a state player as opposed to, in a dispute between 2 private players, the options available would be limited, but the options available to a state player to grant licenses in future and provide preferential tax, access to the country's markets. So that means you can have more creative options at resolving a dispute and not go through the whole hog of a fight. The next advantage would be the formalistic nature of treaty disputes invariably result in even greater time and costs being expended. And so a settlement would have, or even settlement talks themselves would have the mediation, mandatory mediation would have the advantage of, even if it doesn't resolve the entire dispute, parts of the dispute may be resolved. More importantly, by the mere fact that parties had met and tried to seek a middle ground, the experience on the ground in international commercial arbitration is that the level of adversarialism that parties experience in a dispute is thereby to some extent reduced. And of course, in a treaty dispute, the attendant media coverage poses a risk of politicization of the issues in the domestic country, in the host country. And mandatory mediation will provide a valid platform for state players to consider alternative approaches. One other advantage, of course, is the advent of the Singapore Mediation Convention in 2019, which Natalie is a walking expert on. Now, I just want to talk about some other advantages. Non-legal issues may in fact be crucial in ISDS, right? And so there may be more scope for resolving the dispute. And compliance with a treaty award is not always guaranteed. Long exhaustive proceedings may need to follow in enforcement, as Mr. Legum has foreshadowed. And I think it's helpful for a state because, a state bears the risk of being saddled with a high value outcome in a treaty with no rights of appeal. And so, having a mandatory mediation provides the state with a platform for self-determination in the sense that they are able to explore options to determine the outcome of a dispute, outside a formal process, right? And this in particular when the outcome of a treaty dispute impacts many, many stakeholders, nations of a country. So it's all the more important in a treaty dispute that there be this alternative, right? Now, so those are the benefits of mandatory mediation. So I think while there's a dispute or there's some debate as to whether mandatory mediation is suitable for ISDS, I think the consensus, and I would submit, is that the overwhelming sense is that there are many, many benefits. And indeed, I think there is a tendency that we see in a movement towards mandatory mediation slowly but surely in ISDS. Now, I want to talk about the next point, which is the fact that, and many jurists have discussed it, and it is well acknowledged, that the use of mediation, especially mandatory mediation in ISDS, does offer challenges to be overcome. So while we are promoting it, we need to keep a keen finger on the pulse of the challenges that arise. So the first challenge is, when you're talking about mandatory and non-mandatory language, you need to be careful in the way you draft BITs. In particular, I think you need to have an express carve-out from an MFN, most favored nation obligation, because if you have a mandatory mediation clause in a BIT, which also has an MFN clause, one could argue, the investor could well argue, that a clause mandating mediation in that particular treaty, when some other treaty lacked that clause, would mean that that mandated mediation is a breach of the MFN clause. It makes this treaty less favorable than another treaty. So I think one needs to be careful with the treaty, the drafting of the treaty if one were to introduce mandatory mediation. The second issue that I want to raise is that there are serious impediments to a state player resorting to mediation. Now, a very good article to begin with. If you have, if you're unable to sleep tonight, maybe you wish to get something to stir up your imagination. The NUS Center of International Law working paper of 2018 that sets out a number of obstacles. I'm just summarizing the key ones. If a government, a state player, is party to the dispute, there are multiple stakeholder agencies and ministries across all levels of government representing the state, and with different competing policy directives internally and externally. So it's much harder to arrive at a mediated settlement. The next big one is the risk of criticism and politicization of outcome. You may well have a new regime in a country, and it was the old regime which had entered into this particular deal, or it's the old regime that had expropriated certain mining licenses. So settling the dispute from the lens of the new regime may be seen to be capitulating on a key policy point. It may also be seen as creating a bad precedent, and other investors may start taking out action against you. There may be also, in some countries, there have been allegations of corruption when you resolve a dispute and pay out taxpayers' monies. So again, there is a reluctance as a result to resolve the case outside the strict parameters of an arbitration. The last difficulty would be state sovereignty at issue, security issues, national health regulations, as in the Philip Morris case. Environmental issues may be at stake, and it may be very difficult to resolve it by mediation. And usually this also involves sometimes sums in the billions of dollars and vast taxpayer funds at stake. Again, it may be difficult for a state to resolve it. Therefore, the end result is that the state prefers to defer the responsibility to an arbitral tribunal and say, we're not going to be able to resolve this. So that is a feature of treaty arbitration that we need to be mindful of. So the last point that I have, Natalie, so I'm going to finish before my allotted 15 minutes, is that the use of mandatory mediation in ISDS, because it offers challenges to be overcome, certainly my humble urging would be that more work needs to be done on the modalities involved, including pool of mediators, mediation platform, and type of processes utilized. Now, I'm going to set out a number of considerations, part of which is on the screen. So first of all, I will say that it's important that the mediation precedes the commencement of a formal dispute process in terms of treaty disputes, because if the mediation happens after a treaty dispute is commenced and there's a wide media coverage, I think it would be harder for state players to contain the parameters of the dispute. So I think it's an important feature that mediation should precede the commencement of the formal process. I think it's necessary for the international bodies to consider the creation of a parallel mediation body. If you look at what is happening at the national level in Singapore, we have the Singapore Mediation Center, as well as the Singapore International Mediation Center. Now, if the globe wants to seriously promote mediation at the treaty level, disputes between investors and state players, it needs to create a platform that the state players can be comfortable with. And I think that platform needs to be created with the buy-in, involvement, and support of state players. So I think the creation of a parallel mediation body, which is particularly suited to treaty disputes, seriously needs to be thought out. The next consideration I would say is an adjudicative element may be key. I think it is very important, I think, for states where their sovereignty issues are at stake, their ability to control their own destiny, where vast amounts of taxpayer funds may be at stake. I think it's very important for them to be able to inform their stakeholders that they had good reason to resolve it, and introducing some form of an adjudicative element as part of it, even if that adjudicative element is only internal to the state and is not shared with the investor, that may be a useful tool for the state to be able to justify internally why this dispute is better resolved outside the parameters of a strict arbitration. Now, the one other issue that I want to mention, which I didn't have time to include in the slides, is the concern that mediation would negate the gains in transparency from the Mauritius Convention and all the other efforts that are taken at an international level in terms of the resolution of treaty disputes. So this needs careful thought, right? And as Mr. Legum has helpfully pointed out, mediation by its very nature involves private caucuses with the state player, private caucuses with the investor. And so if you want to have transparency, how can you do that, right? Because the caucuses need to stay private with respect to, say, either the investor or the host state. So I think this is something where thought needs to be given. Maybe the common sessions can be, some level of transparency can be introduced, but obviously in terms of confidential information and in terms of private caucuses, the ability to provide for transparency may not be fully present. The one other point I want to make is, I think this is internal to governments. From experience, we find that because of the many ministries and agencies potentially involved in treaty disputes, it's very important for a state in undertaking mandatory mediation to form a special task force, a cross-ministry task force, cross-ministry, cross-agency task force, perhaps created by statute, imbued with the authority to resolve disputes. And we have many examples. Korea, Morocco, Guatemala, and Colombia have successfully carried out such a task force. And with that, I want to say that I would urge the use of mandatory mediation in ISDS, but we need to keep a keen finger on the pulse of the fact that there are serious challenges which are not germane or not wholly germane to in international commercial arbitration, which are present in ISDS, that we need to tackle. Thank you. Over to you, Lee Jun.
Good afternoon or good morning. Let me share my slides. Okay, my topic would be Chinese perspective and experience on the use of hybrid models. And under that topic, I have prepared 3 subtopics: mediation and the Chinese tradition, use of hybrid models in Chinese legal proceedings, and China's perspective on use of mediation in ISDS. Let me start with the mediation and the Chinese tradition first. This timeline highlights the several dynasties in Chinese history in which mediation system has witnessed major developments. As can be seen, the first milestone here is in West Zhou Dynasty around the year 1000 BC, where local magistrates called Tiaoren helped settle disputes, and which is a sort of a mediation. Over the 3,000 years of Chinese history, there has been a few major developments of a mediation system. Basically, the theme is to develop an effective system according to the Confucian thoughts, such as li or rights, to solve civil disputes and sometimes criminal disputes. So traditional mediation in China originates from Confucian thoughts and were aimed at achieving social harmony. One recognized advantage for mediation is that it preserves the nobility of participants. Emperor Kangxi, one of the greatest emperors of Qing dynasty in the 17th century, once said that good citizens would befriend neighbors and colleagues and settle disputes and litigations. Hence, it can be seen that in ancient China, the rulers attach lots of importance to resolving disputes by mediation. With this in mind, let's observe the next subtopic, use of hybrid models in Chinese litigation and commercial arbitration. According to the PRC Civil Procedure Law, for civil disputes, the court, if possible, shall mediate first. And mediation can be conducted at any time before rendering the final judgment. In addition, the court may refer cases to mediation institutions or invite institutions to provide advices, recommendations, and assistance to the court. So this is a sort of a court-referred mediation. And the advantages for mediation during the course of court litigation are twofold. Number one, the settlement agreement can be reviewed and then confirmed by the court so that it can gain judicial enforceability, can be enforceable by court. And number two, the scope of a settlement agreement is not limited to litigation claims. It can be a one-time solution for all the existing or outstanding disputes, not just the original litigation claims, so that the parties can resolve the disputes once and for all. It is better known that mediation are widely used in commercial arbitration in China. Basically, there are two approaches or two practices. One is the so-called RMAT. According to Article 51 of the PRC arbitration law, the arbitral tribunal may mediate dispute before rendering the arbitral award. And the two leading institutions in China, CTEC and BAC, their rules both have similar provisions on RMAT. The other approach is MedArb. Basically, mediation can be commenced before arbitration, and if successful, the mediated settlement can be translated into a consent arbitral award by a specific arbitral procedure, very brief one, according to the rules. This is not in the national law, but instead they are incorporated as provisions in some institutional rules, such as the CTEC rules, Article 47. Here are some statistics, the numbers of cases that have been settled through mediation at Beijing Arbitration Commission, or BAC, as well as the percentage of those settled through mediation cases against the annual caseload. As you can see, in the past 4 years, the percentage has grown from 12% to slightly over 18%. So there is a trend of more popular use of RMAT. Here I summarize two key provisions under the institutional rules of RMAT. One is about admissibility of information and evidence disclosed in mediation in the subsequent legal proceedings. The other is on the form of settlement agreement. As for the admissibility of evidence or information, the basic provision is that for the information disclosed or statement made by the parties or the tribunal, they are on the without prejudice basis status, so they cannot be invoked if the mediation was not successful and the parties need to initiate or continue with legal proceedings. As for the form of settlement agreement, basically speaking, the settlement agreement can be translated into either, as I said, the consent award, arbitral award, or a conciliation statement. Both are equally enforceable by Chinese court. The most controversial issue with RMAT in China is still this issue, the double hatting issue, arbitrator playing the role of mediator. Most of the controversies are not raised by local commentators, but rather they are raised by Western commentators, particularly those from common law background. There are criticisms, and there is an interesting case, Gao Haiyan versus King Ai, in which the losing party challenged the enforceability of arbitral award rendered by a local arbitration commission in Shanxi province of China at the Hong Kong court on the ground of a violation of public policy in light of the what is alleged as improper conduct by the arbitrator and the institutional officers in the process of RMAT. From the Chinese institutions' perspective, their arguments is that arbitral tribunal can only mediate a dispute with the consent from both parties. So if any party is mandated of the negative effect caused by RMAT, they may say no to the tribunal. Then the next challenge would be, some commentators say that it's difficult for counsel or party to say no to tribunal because this would be deemed as a disrespectful gesture toward the tribunal's good-hearted suggestion for mediation. I think this is not a big issue. It's overstated because as experienced practitioners, we all know how to say no to the tribunal without having to say the word no. The other challenge would be mediation by arbitrators are supposed to be on the without prejudice basis. However, arbitrators being humankind, their minds probably would be contaminated during the mediation proceedings, meaning when they resume their role of arbitrators, they probably will, based on what they learned from the mediation proceedings, make the decision. I think this problem is a valid concern, and having recognized this concern, both CTEC and BAC has introduced new provisions in the past 10 years. Basically, the solution is to engage a separate panel or separate team of mediators called independent mediators to undertake the mediation so as to get rid of the concern. So I think I still have some minutes, so I will go on with this subtopic, China's perspective on use of mediation in ISDS. If you examine the international investment agreements concluded by China, there are basically two types of provisions on mediation. One is to prescribe mediation as a mandatory pre-procedure for court or arbitral proceedings. An example would be China-Tanzania BIT. The other provision would be to list mediation as one of the options, along with arbitration and court litigation for resolving investment dispute. An example would be the China-New Zealand FTA. China has this unique feature, but because mainland China has some separate arrangements or agreements with Hong Kong and the Macau SARs and the Taiwan region. Between mainland China and Hong Kong, there is a CEPA, or Closer Economic Partner Agreement, under which the dispute between Hong Kong investor and the mainland Chinese authorities are to be settled by resolution through mediation or court litigation. So arbitration is not mentioned here. Likewise, in the ECFA, or Cross-Strait Economic Cooperation Framework Agreement between Taiwan and mainland China, the dispute should be resolved through consultation by the two parties or in an appropriate manner by the Cross-Strait Economic Cooperation Committee. Here, the appropriate manner is understood to encompass mediation. Again, arbitration is not provided here. So China's attitude towards mediation is also shown in its position paper submitted to Working Group 3 in July 2019, which states investment conciliation emphasizes the value of harmony and can offer the host country and the investors a high degree of flexibility and autonomy. The most recent developments in China is that both CTEC and BAC, who are traditionally commercial arbitration institutions, they now offer investment arbitration rules. And in the rules, there is a clear provision, detailed provision on mediation. And mediation can be conducted by arbitrators. They can also be conducted by the institution. So I understood from the earlier speakers, particularly Mr. Javier, that there are concerns regarding mediation in ISDS. From the PRC perspective, those concerns, for example, desire to defer responsibility for decision-making to third party, those are valid concerns in the Chinese context or according to Chinese perspective. And they are true for both government authorities as well as for SOE investors. I wouldn't have time to go into the details, but let me highlight one point. That is, if mediation is made a mandatory step in the cooling period, would that increase the popularity of use of mediation in ISDS? I think there are different views. There are upside, meaning that government officials, if they are faced with such a clause, they do not have to make a decision about whether to proceed with mediation. And further, with the mandatory provision, whether the state refuses to mediate or refuses to accept what is a reasonable settlement proposal in mediation, the state may be at the risk of receiving adverse cost award as subsequent legal proceedings. So the person, the official in charge, needs to evaluate the risk from settling the dispute, namely the challenges from his peers or from his superior, as opposed to the risk for not settling a dispute that could have been settled at a reasonable terms. So this could probably increase the chances of settlement through mediation in ISDS proceedings. But there are also downsides of this practice. Namely, for thousands of years, mediation has been deemed as a voluntary process. So if mediation becomes mandatory, maybe in the future, the treaty negotiators, they would not be willing to incorporate such a clause into the new treaties. That is my concern as well. So I think I have finished my presentation. So I will hand over to the next speaker, Mr. Blanca Salans-Ferrer, to deal with issues under the European Union. Thank you.
Thank you, Mr. Lejeune, and allow me to try to share my slides first. There. So good morning, good afternoon, and good evening to everyone. I will speak today about the views of the European Union and its member states on the design and the functioning of a mediation mechanism in the broader context of a multilateral investment court. For that, I will start by briefly touching on the European Union's experience with mediation. I will then move on to the views of how said mechanism should work or would work in the context of a permanent structure. After that, I will outline a few of the elements that we consider stand to be relevant in the discussions. And I will then wrap up with a brief conclusion. Mediation is specifically provided for in for investor-state disputes in the most recent agreements concluded by the European Union with Canada, Mexico, Singapore, and Vietnam. This is a significant novelty with respect to previous treaty practice. This is one of the first times, if not the first time, that such framework is provided for in this type of treaties. Now, obviously, the rules and the regulation that are provided for in these agreements are not identical, but they all pursue the same idea of seeking to make available to the disputing parties a framework that is stable, that is structured, and that is clear, and that obviously provides for the necessary flexibilities, allowing them to resort to mediation at any time of their investor state proceedings. Beyond what is strictly the context of investor-state disputes, the EU is also a firm advocate for the resolution of disputes through alternative methods, notably mediation. And we have good examples of that in, as I said, areas other than investor dispute settlement, such as the mediation directive that excuse me, provides for a platform for the resolution of cross-border disputes in civil and commercial matters, the ADR directive, or the ODR, Online Dispute Resolution Directive. Now, moving on, we see that there is a plethora of sets of rules on mediation that are out there, but that they're, however, not resorted to as often as one might expect. So the question for us here is, what is missing? What is the problem? And what do we need to put in place for these rules to be actually and more often resorted to? In the view of the European Union and its member states, the problem is that there is no structure and there is no clarity on what is the process and what's the conduct, but also on the expectations that can be inferred from that. And this leads to a situation of uncertainty and to a lack of confidence in the mechanism. And this is a problem, particularly for states that in an investor state context find themselves essentially in a defensive position. Now, states operate based on their ability to plan ahead and to anticipate, and their inability to do that has an important negative impact on their incentives to eventually resort to mediation. So going back to my question of what do we need to put in place for mediation to be effectively resorted to, the European Union submits that a permanent institution, a multilateral investment court, would bring structure, support, stability, both on the process and the next steps to be followed in mediation, but also on the ability to anticipate scenarios and to infer expectations from those. This increased predictability would result in a virtuous circle of increased confidence in the system. And at the same time, it would imply an ability, the ability to anticipate expectations would also mean that even if eventually the issue is solved at litigation, both parties start litigation with increased clarity on their actual chances of success and whether they might win or lose, or at least on which parts of the dispute they stand to be successful or not. That said, allow me to emphasize again that the European Union and its member states are committed to the creation of a permanent structure that also provides for the resolution of disputes via alternative methods of alternative dispute resolution, and in particular mediation. Now, what are the elements that stand to be a key in this reflection and this discussion? One possible element is the idea of an international ombudsperson. And in this sense, one might draw inspiration from Korea's Foreign Investment Ombudsman Office, which has rendered very satisfactory results, at least partially thanks to the legitimacy and impartiality of the office. But obviously, when thinking on how to transpose this figure, which is essentially, which in this sense belongs to a national setting, into a transnational setting, there are additional elements to think about. On the one hand, this ombudsperson would enjoy increased legitimacy and confidence to the extent that it would be supported by a plurality of governments. At the same time, it would also preserve the transnational nature of investor-state disputes. Something else to think about would be how exactly to do it, to transpose it into a transnational setting, and in particular, how to ensure that fair access is provided for investors and that investors are, well, that the mechanisms are there catering for investors' needs. Additional elements that would need to be considered relate to how to ensure the fairness of the procedure and the efficacy of it. When integrating a mediation mechanism into a multilateral investment court, we would see a pool of readily available mediators as being already there. These mediators would need to have expertise and experience in investor-state mediation, and importantly, this pool would need to be different from the pool of adjudicators that the multilateral investment court would maintain. Mediators would also need to be to abide by a code of conduct, foreseeing strict ethical standards, high ethical standards, to ensure that independence and impartiality are safeguarded, and to ensure that no undue interference takes place. Said mediation mechanism would also need to incorporate the necessary flexibilities. And in this sense, I'm thinking of flexibilities as they apply to the conduct of the mediation, to the timeframes that would apply to the termination of the mediation. And obviously, being part of a permanent court type institution, there would also be some institutional and logistical support provided to the mediation process. I'm thinking in particular of teams of support staff dedicated to those mediation procedures. Something that is also extremely relevant is the moment when the mediation would take place or could take place. And in this sense, we have heard questions being raised by the other speakers today. And there are several options that could be explored because they all bring different advantages. One of the options is to have mediation prior to litigation. And in this sense, one might argue that the investment relation is at least less eroded that once litigation has been formally triggered. But a different option that should be explored as well is the hybrid options when mediation is conducted at the same time or in parallel or in the middle of litigation. And in this sense, obviously something to think about very carefully is relates to the identity of the mediator in relation to that of the adjudicator. And again, here there are different options that one might consider. We can think of the same individual that adjudicates mediating, and that is something that with the necessary guarantees in place can very well be considered. But we can also envisage scenarios where the adjudicator and the mediator are different individuals. One last point that I would like to make relates to the enforcement of mediated solutions, because enforcement is absolute, and this is very clear from UNCITRAL Working Group 3 discussions, is the importance of enforcement. So it might also be useful to spend some time reflecting and thinking and discussing possibilities to have the mediated solution benefit from the enforcement mechanism that would be attached to the multilateral investment court. To conclude, I will only say that a permanent institution would bring added clarity, predictability, and stability to the conduct of mediation. Obviously, such structure has to be sufficiently broad and flexible so as to be able to accommodate existing rules and best practices, as well as ensure equality of arms, while at the same time bringing a sense of that predefined structure to the mediation process, as well as allowing the parties to infer expectations from it, thereby increasing their confidence in the system. And with that, I conclude and give the floor to the next speaker, Professor Hee Tak-shin. Thank you.
My topic is on a very narrow aspect of the potential for arbitrators to also act as mediators for facilitating settlement of dispute. On this issue, there seems to be a divide based on cultural background and legal tradition of civil law and common law. In many civil law jurisdictions, in particular Asian countries, it is taken for granted for a judge or an arbitrator to act as a mediator in the same dispute resolution process. From the efficiency point of view, this approach could result in the most speedy and efficient resolution of dispute. However, common law jurisdictions seems to take a rather cautious approach on this notion. In my view, there is clearly there is a merit for an arbitrator to also act as mediator for facilitating settlement of investor-state dispute. However, in view of the difficulties for state actors in using mediation in ISDS, as mentioned by Francis, I would take a very cautious approach. The experience and practice in commercial dispute resolution could be a good reference point to start discussion. But even in commercial context, diverging thoughts and practice exist with differing degree of arbitrators interacting with mediation and safeguard measures taken to ensure integrity of the process. Slide 4. It has become a general trend of institutional arbitration rules to encourage arbitrators to facilitate an amicable settlement between the parties during the arbitration proceedings. For instance, exceed arbitration rules refer to the possibility of considering the issues at pre-hearing conference with a view to reaching an amicable settlement. ICC arbitration rules in its appendix provides that as a case management technique to control time and cost, the arbitral tribunal can inform the parties that they are free to settle either by negotiation or through any forms of amicable dispute resolution. So this is a kind of trend. 2018 German Arbitration Institute rules go one step further. Article 26 states that unless any party objects thereto, it is mandatory for the arbitral tribunal to seek to encourage an amicable settlement of dispute at every stage of the arbitration. So it becomes mandatory. A special feature in the 2018 DIS rules is Article 20.4, which kind of suggests that arbitral tribunal should also consider providing the parties with a preliminary non-binding assessment of factual or legal issues in the arbitration, provided all the parties consent thereto. It's a kind of evaluative mediation. Another approach is the one adopted in Singapore International Arbitration Act and Hong Kong Arbitration Ordinance. Article 17 of the Singapore International Arbitration Act provides that an arbitrator may act as a mediator if all parties to arbitral proceedings consent in writing, and for so long as no party has withdrawn its consent in writing. If an arbitrator acts as a mediator, the arbitral proceedings must be stayed. If the mediation fails, the arbitration proceedings resume with the arbitrator having acted as mediator to continue to serve as arbitrator. The law further provides that no objection shall be taken to the conduct of arbitral proceedings by a person solely on the ground that that person have acted previously as a conciliator or mediator in accordance with this section. The Singapore legislation requires the arbitrator to disclose confidential information obtained from one party during the mediation procedure to all other parties to the arbitration proceedings before resuming the arbitral proceedings if mediation fails. CTAG arbitration rules, as mentioned, Mr. Lijun, takes a very similar but somewhat bold approach. With the consent of both parties, the arbitral tribunal may conciliate the case in a manner it considers appropriate, and if mediation is not successful, the arbitral tribunal shall resume the arbitration proceedings and render an arbitral award. This is CITAC arbitration rules. And a rather different approach is found in ICSID arbitration rules, which do not include any provision as to whether an arbitrator could also act as a mediator. However, Rule 1 states that no person who have previously acted as a conciliator or arbitrator in any proceeding for the settlement of the dispute may not be appointed as a member of the tribunal. Thus, once the arbitrator have acted as a mediator, he or she may not serve as an arbitrator if the mediation fails and the arbitration procedure has to resume. I think that in the context of ISDS cases, we need to carefully weigh potential benefits against potential risks of having arbitrators also act as mediators in consideration of obstacles identified as presenting serious difficulties to state parties in utilizing mediation. As Francis elaborated, there are many obstacles, including public perception and criticism against irregular dealings or even corruption behind the scene, demand for transparency, potential personal responsibility of officials involved, and also stringent public scrutiny under political pressure. Of course, the benefits of having arbitrators to act as mediators are obvious. By having arbitrators who are familiar with the dispute and the parties' factual and legal positions to also act as mediators, substantial time and cost could be saved. Accordingly, it would contribute to the efficient resolution of dispute between investors and states if mediation is successful. Further, it would contribute to the restoration of peace and long-term relationship between the parties in dispute. However, if the mediation fails and the arbitration has to resume, the potential risks and the possibility of substantial additional time and cost if mediation fails and arbitration has to resume, not all the parties may be comfortable to have the same arbitrator to continue to act as an arbitrator in the resumed arbitration proceedings. The foremost concerns could relate to the doubt on the impartiality of such arbitrator who have caucused with one party and might have obtained confidential information. It would cast doubt on the integrity of the whole arbitration procedure itself. To address this concern, both Singapore and Hong Kong legislation require that arbitrator makes a disclosure of such confidential information to all other parties in the arbitration procedure. But this could have a chilling effect, particularly on state parties and their officials. However, due to those concerns and objections by the parties, if a new arbitrator should be appointed when the arbitration procedure resumes, it could take more time and cost in the ultimate resolution of dispute. In conclusion, I believe that there is potential for the arbitrators to also act as mediators, but in order to maximize potential benefit and reduce the associated risks and to make state actors a bit more comfortable with the use of mediation, I would propose a rather cautious approach along the following lines. Maybe given the time constraint, I just give you the conclusion that only if the parties agree that arbitrators are the most suitable mediators given the particular circumstances of their case, at the request of both parties, the president of arbitral tribunal or the sole arbitrator could act as mediator and conduct mediation. The parties and arbitrator who agree to act as mediator should have a clear understanding that if mediation fails, the arbitrator who has acted as mediator shall resign in principle from the arbitration proceedings. If mediation fails, the arbitration process resumes with the appointment of new president or sole arbitrator. Only if at the time of resumption of arbitration proceedings, after having reviewed circumstances, including potential concerns arising out of confidential information the arbitrator obtained during the mediation, all the parties and arbitrators having acted as mediator agree. Only if all the parties and arbitrator agree, he or she may serve an arbitrator in the resumed arbitration proceedings. But still, I feel that it has some element of risk when it was challenges at the stage of enforcement or set of proceedings. National judiciary may take somewhat different approach depending upon their legal tradition. Thank you very much.
Thank you very much to our distinguished panel for walking us through and exploring some very interesting issues relating to a number of points on hybrid models. We have a very active Q&A segment coming up owing to the questions that have been posed during the course of the presentations. So I'll dive straight into it. The first question that was asked relates to whether or not there are concerns over the same neutral or double hatting in the context of mediation and arbitration and hybrid processes. And I think this was adequately responded to during the presentations by Bart, by Adrian, and by Professor Hee-Teck Shin. So I'm going to skip over that. Thanks very much to Adrian Lai for that question. There was, however, a question relating also to this issue of one or different neutrals. And that's been posed by Tanya Ratswa Manhombo. And the question is an arbitrator necessarily a good mediator, and are the skill sets the same? So I'd like to pose this to our distinguished panel. Perhaps Professor Hee, you can kick us off with the answer to this question, and then any other panelists who'd like to jump in.
Yeah, I think that's a very good question. And I feel that in general, the skill set of mediators are different from skill set of arbitrator. And secondly, the perspective of arbitrator tend to focus on legal claims. Arbitrators, after reviewing the party submissions and legal positions, they tend to think within the context framework of the claims, while mediators would be much more flexible, and they can really think about the much broader factors to put on the table. I think this is one of the points mentioned by other speakers. So in the context of ISDS, where state has various tools beyond the claims brought by the claimant, I think the mediators or arbitrator with suitable mediator training would be in a much better position to come up with positive outcome.
Thank you very much, Professor. I've got some questions that are directly posed to some of our panelists. Before we get to those questions, does anybody like to add to this question that was posed?
I don't see any takers for that. So on to the issue of, or rather still on this issue of one or different neutrals in some sense, is a question from Sherlock Kim posed to Francis and to Barton. The Hong Kong mediators are subject to impartiality of the Hong Kong Mediators Code. And the question is, do you think that such a binding code would address your concern, relieve your concern about caucusing as an opaque thing? Perhaps Francis, please.
Right. I actually dropped a written answer to that question. I think the opacity issue that I was addressing was the criticism that if you had mandatory mediation in ISDS, the mediation is going to be cloaked without prejudice, secrecy, and the cloak of confidentiality, perhaps. And in particular, the separate caucuses would mean that what happens at each individual caucuses would not be completely transparent to the public. And so that is the criticism of introducing mandatory mediation in ISDS, that somehow it would detract from the level of transparency of the ISDS process and related process as a whole. So I didn't mean to raise any issue of ethical compliance on the part of the mediators involved. So in that sense, I think that concern certainly doesn't arise from my focus on the point of, the lack of transparency. Thank you.
Barton, would you like to chime in on this as well? It was also posed to you.
Yeah, just very briefly, no, I agree that there is absolutely nothing improper about a mediator that engages in caucuses. That is, as I said in my presentation, that's one of the strongest tools in the mediation toolkit, and it is expected and entirely proper for a mediator to do that. Does having a provision in a code of conduct that requires mediators or arbitrators to be impartial resolve the issue of the same neutral serving in both arbitration and mediation? My answer to that would be no. Just as arbitrators are already obligated to be independent and impartial, having that as part of the standard does not relieve a court of reviewing whether a violation of that standard has given rise to a fundamental breach of due process.
Thank you to our panelists for really concise responses to all these questions. We've got a question also posed by Mark Apple regarding clearing the path towards mediation. So his question is, how important is legislation making clear the preference for mediated agreements in disputes involving the state? Perhaps we can hear from Li Jun on this, and any other panelists who'd like to step in.
Honestly, I'm not aware of any such legislation, but I think it's probably not quite realistic because legislation are supposed to be only governing or binding upon state or the investor of that particular state. It cannot be in the context of a treaty arbitrations. I don't think it's quite useful. That's my perspective, but I may be short-sighted on this. I mean, in the larger context, if you have a similar provisions for commercial or private dispute resolution, encouraging, this use of mediation, then it can be, encouraging in the larger context any party, including state parties and SOE parties, to use mediation in any of their disputes. So in the long term, it may be useful, but for the short term, I don't think it can easily achieve the goal. Thank you.
Thank you very much. We have a series of questions in terms of design of the process and institutional design as well. I've got a number of questions posed to Branka regarding the multilateral investment court proposal. We've got Matthew Swen asking whether, given there are existing institutions such as ICSID that offer institutional mediation services for ISDS, Do we need a new MIC to deliver similar services? He's pointed out that the COVID-19 pandemic has adversely affected the economies and possible public finances of various jurisdictions. And so is it realistic to expect these various jurisdictions to be able to pool together resources to establish the MIC within a reasonable time frame? We've also got, I'm going to throw a few more questions at you as they come from various quarters. We've got also questions from Tanmai Apte on the benefits of mediation to the EU proposed multilateral settlement system, which shall work somewhat like the WTO appellate structure, as well as how can we say that there are cost savings when the states, especially underdeveloped and developing countries, have to pay heavy costs when they lose the dispute. So looking for an explication of some of the benefits and also the cost savings that may emerge. The other question and the final question to Blanca, perhaps you can give us a holistic response to all of these questions, is from Brian Chang, asking, while we understand that the EU supports mediation within the framework of the proposed multilateral investment court, will the EU be open in principle to supporting other proposals concerning mediation, such as the creation of guidelines or model instruments on how states can manage investment disputes that will facilitate mediation? So quite a task for you, Blanca, but I'm sure you're completely up to answering all of these questions. Over to you.
Thank you, Natalie, and thanks to everyone who posed this extremely interesting questions. I attempted at briefly replying at the first one of those in writing, but to give a bit of a more comprehensive reply, I'd like to clarify that the idea of establishing a multilateral investment court primarily seeks to address the concerns that affect the current system of investor-state dispute settlement. And these concerns have been discussed at length in the context of Working Group 3 of UNCITRAL, and they relate at the core to the poor legitimacy of the system, the lack of predictability that ad hoc arbitration leads to, and the exceedingly high duration and costs of these proceedings. Now, it is how do we bring this together with the idea that ADR is a cost-effective mechanism to solve disputes? Well, since we create the court, it makes sense from the point of view of efficient use of resources to use that structure that will be created also to provide some certainty and the necessary structure for the conduct of ADR and not only litigation. Obviously, there is a very pertinent comment that rules already exist, and we are aware of that, and it's true. But as I attempted to explain, what's missing is not yet another set of rules; is an actual structure. There was also a comment on how it relates to the WTO dispute settlement, and obviously it's not a secret that certain elements of our thinking on the design and functioning of the multilateral investment court are at least inspired by the good functioning for many years of the WTO dispute settlement. And in particular, I would like to highlight here the idea that we would have a double instance, so a first instance and then an appeal tribunal that would bring added predictability and clarity to the system. On the issue of costs, it is true that this type of procedures are costly, but there are ways to contain, at least partially, those costs. And one of the ways is by establishing predefined timelines to avoid that processes get out of control. And this brings me also to the mediated solution. If the parties reach one, that obviously there will be a cost, but it will not be a cost supposedly that one of the parties cannot cannot assume. However, having, as I said, mediation in the context of a broader structure would also bring added clarity to the parties on their chances of success. So one might expect that this would also contribute to contain the costs. And finally, there was, I think, a comment on whether we would be ready to consider also other solutions, such as guidelines. I'm not sure I fully grasp the sense of the question, but what I can say is that we are already having, and we look forward to continue having, a very open-minded and honest discussion on what is the best way to address the problems, on what are the best solutions to address them, and what the solutions that work for most of us. So I think that I hope that captures the several questions posed, and thanks again.
Thank you very much, Blanca, for dealing with the suite of questions. I have my eye on the time, everyone. Thank you so much for a really engaging session. We didn't manage to get through all the questions. So thank you very much to those who posed the questions, and apologies we couldn't get to them. Questions on the ECT, questions on double hatting. So Nadia, Samantha, and Livia, thanks for raising those issues. Shreyas Jayasima asked a question that Francis has replied to in the chat box. So we've got a number of closed questions, a few open ones to continue to think about. Thank you to our panelists for a thought-provoking session, and to our active participants who have engaged us thoroughly throughout our afternoon, or the third session of the day. A very good day to all of you, and please stay on for the fourth session. Thank you, everyone.
That's the end of session 3. We now come to the fourth and final session of the day. The topic for this session is the way forward for mediation as a reform option for ISDS.
Good afternoon in Hong Kong, good morning in Brussels and in Vienna. This is the fourth of our sessions, and the last one also for what has been a very intense and very fruitful discussion and deliberation so far. I'm delighted to have with me three eminent and very experienced speakers to help me look into the way forward for mediation as a reform option for ISDS, which is to focus the discussions we had so far onto the agenda of Working Group 3 and how we can turn this, all these ideas and all these views that we have heard so far into practice in developing the reform option to strengthen mediation as a tool to sort out ISDS disputes. Now I have with me Alejandro Carvalho Leda, and he's going to talk to us about his very focused experience in developing, setting up within an existing treaty, the Energy Charter Treaty, a mediation system to offer not only arbitration as a means to settle disputes, but also investor-to-state mediation based on an investment treaty. So we will hear from Alejandro. We will then hear from Charlie Gardner-Gunshorn, who we have the pleasure to have as a delegate leading the Thai delegation in Working Group 3, who is going to talk to us about provisions on mediation services by an advisory center on international investment law, which is one of the reform options that has been strongly called for by developing country members of our working group and has been pioneered by Thailand. And then we will have the pleasure of hearing from Dinai Ritu from the Attorney General's Office of Mauritius on the role of capacity building to in the way forward of the use of mediation in ISDS by states, because one of the recurrent points we have heard so far is that while treaty provisions offer possibilities to resort to mediation, although this is also an issue that will need to be strengthened in treaty language and also in the institutional setup. But we've also heard that one of the recurrent issues is the absence, or should I say, the rather limited pool of ISDS mediators, of people who both have the experience of dealing with states and also have the experience of investment disputes and are mediators. So I know that efforts are underway to create such a pool of mediators for states and investors to resort to. So because we have a lot of very interesting presentations going forward, and we have limited time, it's the end of a long day. So I would like, without further ado, to give the floor to Alejandro and to ask him to walk us through tools to promote a greater use of mediation by states in the ISDS context. Alejandro, the floor is yours. Thank you.
Thanks, Anna. And let me first thank the organizers, UNCITRAL, the Department of Justice, and the Asian Academy of International Law for the invitation to speak at this very interesting panel. I would also like to recommend to all of you to have a very good look at this background paper for the panel that it really provides a very nice overview of the topics we are going to discuss here and some of the topics that has been mentioned probably before in the previous panels. As mentioned by Anna, my topic is basically focused on tools that can promote the use of mediation by states in investment disputes. Nevertheless, having said that, we can also mention that most of those tools can also be very useful for the companies. It's true that the states have a very complex entities with different departments, ministries, sometimes competing interests, and they may have some reluctancy to enter into settlement agreements due to potential allegations about corruption or fraud, but similar concerns appear also in the industry. They also are complex entities, many times with the parent companies, subsidiaries, the project in the host country, competing interests between different departments, and also the reality that they need to face their own stakeholders and try to convince them why it's better to reach an agreement when on the other side they may also have an internal memo or document saying, well, there is a clear breach of a contract. So let's face the reality is you need both to really settle a dispute. You need the industry and you need the states. So both of them need to address the potential obstacles for investment mediation. I will focus now then with some tools that could help overcome those main challenges, obstacles that we have identified in different roundtables and different workshops with industry and also government officials, representatives. We'll try to divide this presentation into two main issues. The first is raising awareness, and this is really key, really important. Why? Because the lack of knowledge derives in lack of confidence, lack of trust. You really need to build a culture of investment mediation, to raise awareness, to make all the stakeholders that are going to use it feel confident and really using it. How do you deal with that? One tool is capacity building. I will not really talk too much about this because it's some of the topics that will be one of my colleagues will be speaking later in this same panel. But basically you have trainings, you have workshops, you have conference, and the important thing is that yes, they have several of them dealing with investment arbitration, dispute resolution in the investment area, but you need to make sure that these are really targeting the investment mediation and how mediation can be used and who can use it, when it's the right timing, and what's the process. But more important is that these trainings, this capacity building, should not only be focused on government officials. The important thing is also to address the industry and the lawyers, because sometimes, of course, lawyers will be involved in those investment mediation process. And the National Secretariat has already prepared and organized some of those workshops, but it's very much welcoming additional efforts in this side. A second instrument is a guide. In 2016, the UNCITRAL conference endorsed a guide on investment mediation. This is a tool that clarifies, or at least tries to clarify and to explain several important things. First, what is mediation? And in particular, what it's going to be investment mediation. What are we talking about? There are different names: conciliation, mediation, structured negotiations, supporting talks, whatever it is. What are we talking about? Second thing, where does mediation fit in the picture? At the very beginning of a dispute, can be in parallel of investment arbitration. At the end of an investment arbitration, maybe when you have an award, is it still possible? Where does it fit in all the different mechanisms you have there? Third thing, a very interesting one we try to address in this guide, is how to assess which are the different factors, circumstances you may consider to understand whether for this particular dispute you have in front of you, or for part of it, mediation could be useful. And even more, once you say, yes, I think it is a potential tool I'm going to use, how do you propose it to the other party? How you break the ice? How you invite the other party to dance with you on this process? And once you say, okay, I overcome those things, I'm sure this is, the right tool, it could work, I have the other party also interested, how do I prepare? I mean, you just don't jump in a meeting out of the blue and start discussing how to solve the problem. You need to understand the problem, what's behind it, what are all the circumstances, what kind of documents you need, who are the persons who need to go with you and prepare the things with you. You need to prepare logistics, documents, etc. Also to understand what is going to be your role as a party and what's going to be the role of the lawyers. It's not the same as investment arbitration. So you need to know exactly who is playing what at which point in time. In addition, we provide, to 2016, some overview of the existing mediation conciliation rules. Of course, these have evolved, but even more important, what is the supporting role of the institutions? And this is key. We provide some tips there. For example, they help to secure the agreement of the parties. There maybe the investor is very interested, but the state is still reluctant, not convinced, and needs more clarification. So an institution is an external neutral entity who will help to clarify and solve concerns and provide additional information for the reluctant party to say, well, maybe yes, it could be considered. Furthermore, it helps also, and is related to bring more confidence and trust, but not only from the parties, but from all the stakeholders. It's important that take into account, as we'll talk later, that the confidentiality requirements, then the stakeholders will have the confidence that nothing is strange behind under the table because there was an institution there making sure there was a due process and nothing really strange is going on. And in addition, the institutions can also help to overcome initial logistical problems. For example, where do we meet? We want to mediate, but we cannot even solve the issue of where are we going to conduct the discussions, or securing visa. Some government officials may have problems to enter in a different country, to sit down and negotiate with investors. So there are a lot of things that institutions can help with, apart, of course, of providing additional assistance during the process. And not less important, help the parties identifying right, trustworthy candidates for mediating the dispute. Additionally, another topic that was covered by the guide on investment mediation was this particular issue of selecting the mediator. Which are the characteristics that could be useful for a mediator? What are the factors you need to take into account or to consider when You are thinking about who could be the right mediator for your potential dispute. Again, these are different tips, guidelines, ideas that could help the parties to understand better what is the investment mediation and what are the different issues they need to consider or to which they need to prepare. And this is a guide that was done in cooperation with several institutions, with UNCITRAL, exit dispute resolution entities, but also government officials and the industry. Now, a second important block, and that's effective implementation. We found out that industry, governments, in many cases, they were interested in going to investment mediation. But nevertheless, there was a question about, are we ready? Are there really rules there that will be apt and available and we can really use in an effective manner? Are we really internally prepared for that? Do we know how to? And this deals to a next tool that was elaborated by the International Secretariat, which was the model instrument on how to deal with investment disputes. And this was elaborated in 2018 and by the conference and provides a model, a guideline, a helping document with several policy options which can be tailored by each of the different states to their own realities, to their own circumstances. Provides different options, and then you choose what is more interesting, useful, or fits more into your own model. The reality shows that this is not only helpful for the states, but can also be very helpful for companies, since not all companies have already an internal mechanism for the things I'm going to explain now. What are the key things that we find in that model instrument and could be useful for effective use of mediation? First thing, establishing, identifying a responsible body. Who is in control? Who coordinates? Second thing, a clear and express legal basis for negotiation and mediation. We saw that in many countries, yes, there is a ministry or an entity in charge of defending the interests of the state in international tribunals. Does it mean it can negotiate? Does it mean there is a possibility of mediation? Can reach agreements? It's not very clear. Now, we all know what happened in the early years of investment arbitration. There were defenses, the Constitution does not allow in those cases arbitration. Will the same things happen once you have a settlement agreement after a mediation? Well, you need to have a clear, legally binding framework in the country saying, yes, the state can mediate under the circumstances or whatever conditions. Second, this needs to include the authority to settle. Who has the right to put the stamp on the final agreement? Who will take the final decision about payments to be done, get back a license, or whatever has been agreed there or could be agreed? And more important, decisions regarding financial issues. So some people go to a different country, sit down, negotiate, mediate, how they pay the travel, how do you pay the witness, how you pay the mediator, where you get the money from. This is important. And more important, if the agreement says, well, there should be a payment, how you secure the payment, how you make sure that the payment will be there and it's being authorized, who gives the final okay. Also important, an early independent assessment of the dispute. Important thing is the states should not rush into the arbitration because there is a notification, they don't know who deals with that one, at the last minute they rush and they follow, end of the story. They need to sit down, they need to assess, is this dispute part of the dispute, can be taken to mediation, can be solved through negotiation, can we solve in a different way, yes, no, what are the problems, what are the benefits? You need to consider this, and in this strategic thinking, you need to also make sure that mediation is in there, and not only arbitration or negotiation. You have to see all the potential instruments you have at your disposal. And finally, how to deal with the tension between confidentiality. Clearly, in a confidential environment, the parties will be able to really find out what's behind the real problems that, everybody thinks it's about this and that, but the reality behind that may be other things. And you can only find out those things in more of a confidential environment. But at the same time, there are transparency requirements in many countries. And also there is the interest, because it's a public policy issues there. So there is the real interest of the media the civil society, the other political parties. You have to deal a balance between both things. How to deal that? Then it's important to have an early strategic communication plan. You need to know in advance how you want to deal with those issues. And you need to discuss with the other party. If things happen, how do you want to deal with the press? Or what kind of things or documents can be communicated? The fact that there is a mediation, the fact that it started, it's finished, what is going to be said? Otherwise, you enter into endless discussions. Once it's got out, it's blown out, and the media is in there, and nobody has any more control about it. And there is a dispute about you misbehave, I stop the mediation, and all these kind of things. You also need to identify the spokesperson. You need to know who is going to be the right person that will communicate things on behalf of the party. And the same, stakeholders need to know who is the person they can go to get more information. And this works exactly the same for the companies. They need exactly similar things. Another issue for effective implementation, updating applicable rules to make sure that the applicable rules are really updated and really effective, taking into account all new developments. That's something that ICSID is doing, UNCITRAL is considering, and you need to take into account, for example, of the next point, which is enforcement. What's one of the major problems for the industry? How to make sure, if I had a problem with the government and didn't comply with their obligations, how I make sure now that the settlement agreement will be complied with? And then you have the UN Singapore Convention, very useful. We hope that it will really go ahead and will be very used. But for that one, you need to make sure that also this is expressly taken into account and considering the new applicable rules. And finally, training investment mediators. There were concerns about investment arbitrators. Same concerns will come with mediators. How you make sure there is available people capable with the abilities to follow the process, to explain, and to really give that trustworthiness and confidence to the parties. And that's why the HR Secretariat, together with ICSID, IMI, and CIDR, have provided already trainings on investment mediators since 2018. The next one is online, and the last one were with the support of Hong Kong Department of Justice. And I think those are the main issues, and I will just pass the floor to my colleagues.
Thank you very much, Alejandro. I think you've given us a very clear overview of all the very useful tools that you have put into your toolkit in the Energy Charter Treaty, Secretariat, and also the support that you're giving to states. Obviously, all the impediments, all the issues that arise in the context of a mediation have been very carefully thought through and very well. You're providing very good responses, and I'm very grateful for you sharing this experience because it's, as you say, it has been a process. So you have started looking into mediation a couple of years ago already, and you've come up now with very good tools. 2 points that I would like to just highlight before giving the floor to Charlie, who's waiting for the floor, is I found the point you were making about giving the negotiators or the participants in the mediation from the state side the necessary tools to ensure that they have the power to engage, that they have the power to make decisions, and to ensure that these decisions will also be enforced. And I think the point you were raising about confidentiality is definitely an issue in investment mediation because of the increased call for transparency in investment arbitration. One way or the other, this will have to be tackled. So thank you very much for this, Alejandro. And without further ado, I give the floor now to Charlie to look into how an institution that has been called for as a reform option could also deliver on this other reform option, which is strengthening ISDS mediation. Charlie, you have the floor, and Alejandro, thank you very much.
Thank you, first of all, to Anna and to the Asian Academy and the organizers for having me. Today, I'm going to talk about the provision of mediation services by an advisory center. Now, At the outset, I think it's important to highlight several general points. The perspective from which I come from is a government perspective, in particular, a internal counsel, internal legal advisor's perspective of a government. So that will be very different to a external counsel and academia and other people in general. Thailand supports the establishment of an advisory center strongly, partly due to our experience with the ACWL from the WTO context. We have found their work to be very good at a very low cost, and it's helped us a lot actually to understand WTO law and to help us in the cases involving WTO law. We have indicated this in many of our papers. Obviously, we understand that the concept of establishing a center is easier said than done. There are many things that need to be ironed out and details which need to be discussed. So in this context, in addition to the obvious work of the AC, well, what I will call the ACIIL, I suppose, on litigation, I'd like to explore today the things on mediation. Several good points were already made this morning, in particular, the importance of mediation in the ISDS context. And also, it's great to see the developments on mediation, be it the work in ICSID or, like Alejandro said, the Energy Charter. So that's part of the work that needs to be done. Another point which I'd like to make at the outset is that the impediments to the use of mediation, in my experience, depends a lot on the state and the country and the legal culture of that state, which I will outline in just a minute. And another point which I like to make at the outset is that mediation is not just good on its own account. Mediation is also good as helping the arbitration process. So in Thailand, we very much benefited from the Med-Arb-Med process and the Arb-Med-Arb process. So mediation as a tool to help the arbitration is also very important. That's an overview of my talk today. So I will outline the impediments to the greater use of mediation in ISDS, the possible role of advisory center in advancing mediation, and the potential limitations of a center and the way forward. Now, this is key, I think, to success to mediation. Why hasn't mediation been more popular? Well, from our own experience, the first point is that there is very much a lack of familiarity and know-how with regards to mediation. Why? Because in a state, there are many agencies involved. This was highlighted before, but I think I'd like to highlight it a bit more in that, for example, for Thailand, we at the Foreign Affairs, we are international law experts, right? There will be people who are domestic law experts. There will be line agencies. There will be engineers. There will be other people involved in a particular case, right? Who outside the legal experts will have very, very limited knowledge on mediation. You know, this is, you see litigation in the movies, but you don't see mediation in the movies, you know, so it's something that they're not used to, right? So once you start at the committee table or the meeting, internal meeting, and you think, and you mention the concept of mediation, straight away people think, what's that? You know, what does that involve? What's going on? You know, that's certainly the lack of familiarity. And the point on lack of know-how is that I think this is the case in many states, but the mechanism, legal mechanism for states is especially geared towards litigation. It is not geared towards mediation. So for example, the typical public prosecutor will not be involved in mediation, at least in my experience, on a regular basis. They are geared to carry out, you know, aggressive litigation. That's their job, right? So when you mention something that they are not familiar with, then, you know, it's only natural that it's not taken up. The second point which I like to highlight is third-party settlement versus agreed settlement. This has been lighted previously this morning and this afternoon, Thailand time. And the point is this. The point is arbitration is a third-party settlement, right? So it's clean, right? In addition to the point that's what is made this morning that you can blame a third party for the outcome. It's also much cleaner than mediation. Clean in the sense that in mediation, a lot of the internal mechanisms needs to be involved, right? And it's a lot of going backwards and forwards instead of the litigation process, which is pretty much a one-way street or a one-way and then a return. You know, it depends how many submissions you have, I suppose. But mediation is very much it's very detailed, and it requires a lot of minor handling for the agencies. And I don't think a lot of people like that, right? And that's the agreed settlement option. So the agreed settlement option involves a lot of tiny details. The next point, which was made also earlier, which I like to go into detail, is the fear of criticism. A lot of people who don't work for the government, right, I think often think that the government is a whole unit in the sense that, you know, in terms of timeline. So what the government did in the past, this government agrees with or takes responsibility for, right, which is certainly in countries with political climates which are not stable, is certainly not the case. So the person who issued the measure, which is in dispute, in many circumstances, are not the people now doing the litigation, or at least at the political level, right? So that's the problem that we have to deal with. And also, which you mentioned earlier, if you strike a deal with the claimants, you know, how can you answer questions on allegation of corruption? Was there an under-table dealing between government officials and the investor, right? And if you're the typical government official, it's perhaps easier to be risk averse, you know, to say, oh, maybe not, you know, I'm not going to take this option and just let the arbitration decide. Why risk it, right? And the last point, which I like to outline, which I don't think was mentioned today, was that for mediation, there is no guaranteed outcome, right? For arbitration, there is. You either lose or you win. But for mediation, it might be just money wasted and time and effort, right? And if you say to your superiors or your boss, you know, I like to suggest mediation, sir, you know, and they ask you, can you guarantee the positive outcome? You know, the good lawyer will certainly say, no, I cannot. You know, there is a potential of a better outcome, but there is no potential of a guaranteed outcome. So, and then they ask you, how much will it cost, you know, in legal fees? And then you say, maybe a couple of million, right? And, you know, the sensible man would probably go, well, maybe it's better to save that money and put that all in arbitration. You know, that's one line of thinking that's, I think, face many government internal counsel. So this slide summarizes, in our experience, why mediation has not been that popular, at least from the government's perspective. Now, going on to the advisory center, it's important to highlight that there's a lot of work already done. So there's no point repeating work that's already been done. You know, it's just a waste of time. So as you can see there, there's Anna again. I think that's an exit training workshop. The Energy Charter, as you have heard, has guidelines on mediation. It's also done very good work. There is also very good work that's been done in the mediation rules of the IBA. We can also build on that, right? And the exit rules, obviously, that Madam Secretary mentioned this morning, the 2020 rules. So all this very good work is being done on mediation. But I think the fear of mediation for states, or the hesitance, it's still there. So how can the advisory center help to address this issue? Well, that should be slide 3, I'm sorry. But I've divided the role of the advisory center into 3 categories, right? The left column is the role that they can play before deciding to join the mediation. So what can they do, right? The advisory center is very important, and it hasn't been done before in the sense that it could be the first, let me call, neutral body on this issue, because previously you had law firms, you had a counsel, but they're not seen to be neutral in the sense of an advisory center, right? Or at least not as neutral anyway, because there could be the usual argument of lawyers wanting to charge more and advising this and that. Now, on the left column, what could an advisory center do, right? They could explain to government officials of all departments, more importantly of the line agencies, what is mediation? What is it? What does it involve? And what are the advantages and disadvantages of mediation compared to arbitration? I believe that if the advantages are highlighted enough for the government officials, I think this would be the preferred route. Obviously, this has not so far been the case. I think for many states, the arbitration is still the preferred route for the reasons that I've previously highlighted. And also, what are the aspects of the process that states should take into consideration, i.e., by this I mean, what are the internal mechanisms that need to be set up for mediation? A lot of states don't have internal mechanisms that are geared towards mediation. A lot of our decision-making process are geared towards arbitration and general litigation, but not mediation. Also highlighting the point I made earlier, the third-party settlement versus the agreed settlement. Obviously, the decision-making process need to be different to allow for officials to work most efficiently and without blame. Now, the second column, which I like to highlight, is the role of the center, right, during the decision-making process, right? So what the center can do is that obviously it takes the neutral, again, role, and it can provide an evaluation of the case, right? And whether a mediation is likely to be successful, right? And in addition, work can be provided on the nitty-gritty of mediation, who's a good mediator, right? And that sort of thing. At the very outset, when the states are trying to figure out whether the mediation process is for them. The third part, the role of the advisory center can play is once the states have agreed to mediate. Now, this is the process which can fill in the vacuum, which I mentioned earlier about the know-how as well. The internal organization of the state, how it should work, how mediation works, how we can present the material without prejudice, the concept of confidentiality, which is dear to many states, and transparency also, finding that balance, right? And I think very importantly, providing on the information on who is a good mediator to suit that particular state. Right, so I think these are the issues that an advisory center can help states on, but the advisory center's help on mediation is without problems in our view. So what are the limitations? Now, first of all, it's always the classic dilemma of cost versus scope, right? For the moment, we, as you probably all know, the ACWL is not very big, right? And if the ACIIL were to offer services to extend to mediation as well, what would that cost? And who is going to pay for it? especially at the initial startup stage. Now, the quality of service, right? As you know, as practitioners, mediation is a different skill set altogether to arbitration or litigation in general. You need experts on this, right? Can the staff of the advisory center be trained in mediation? And to what extent should resources be pooled away from what I assume to be the core competence of the advisory center on arbitration or litigation towards mediation? Now, that's a question that needs to be addressed, right? The trust and reliability, right? This needs to be established, and it will take some time, you know. And the advisory center will work well if it has the trust and the dependability, right, from states. Now, to what extent that can be done and over how long, this also needs to be addressed, right? So that's another limitation of the advisory center which needs to be worked on. And the last point which I like to make is, if the advisory center is to expand its scope, as discussed in many fora, towards other people, investors and, you know, developed countries, right? To what extent is there a conflict of interest, you know? And what scope should the advisory center play towards the investors and the states, right? So those are my points. I'd like to conclude there. I haven't answered a lot of questions today, I'm afraid. I raised more questions which needs to be addressed in the work of the working group, but I think they are valid questions in the context of the advisory center. Thank you very much, Anna.
Thank you so much, Charlie, for this very comprehensive overview of what an advisory center could do. It calls for two quick remarks. One, how nicely it ties into the presentation by Alejandro on the role that an institution can play to facilitate, and not only a mediation institution, but in this context, the very institution that would be helping developing countries in disputes. So thanks for dovetailing so nicely. And the second point, it calls, as in terms of comment, it calls for is that the UNCITRAL Secretariat, together with the IAI and the International Law Institute, is hosting a webinar on the 16th of November, where you feature among the panelists, Charlie, where we will be discussing precisely costs and financing of an advisory center on international investment law. And one of the topics will definitely be the scope of what this advisory center could do, the scope of services. And from there, of course, we are going to have a discussion about the need for special personnel to deal with mediations. I see that one of the authors of a very interesting study, Ndanga Kamau, is with us online, and she will definitely give us her insights onto the importance of this center also supporting mediation and not only arbitration in settling these disputes. So thank you very much for that. Before I give the floor to our colleague, Dinai Ritu, I will just remind all our participants that there is a chat box that is available for any questions you would like to ask the panelists, like in previous sessions. So feel free to add to the one question that we have already in the chat box, and that will help us then in designing our question and answer session. Thank you very much. And now, without further ado, over to you, Dinai.
Just 1 second. Yeah, that's done. Yeah, good morning, good afternoon, and good evening, because we are all in different time zones. And I'm grateful to the Secretary for Justice of the DOJ of Hong Kong and to the AIL for having me for this panel. Without further ado, I'll start my presentation. So I think there's a lot of scope for capacity building in enhancing the use of mediation in ISDS internationally. And we can see that this can be useful in three main areas. That is, mediation can be an alternative to arbitration. It can also be used alongside arbitration. And we have to bear in mind that as compared to arbitration, and that is an issue that has been alluded throughout, this is an area which has not gained international acceptance. And we've had the views, expert views of Alexandro and Charlie on this issue. And even this morning, distinguished panelists shared their experience on that. What is the state of play right now in relation to mediation? I think we are living extremely interesting times. And one of the articles that I came across in preparing this presentation is one by Charlampos Kenakopoulos from the Center of International Law, which is titled Investor-State Arbitration Meets Mediation, the view from UNCITRAL, and this is dated 1 October 2020. And we learn from this article that we have a rising interest globally for ADR in investor-state disputes. And indicative examples from investment treaty making confirm this, including the USMCA, the CPTPP, the EU investment agreement with Canada, Singapore, Vietnam, the China-Hong Kong CEPA, and also the Energy Charter Conference, which adopted a guide on investment mediation to facilitate ECT parties in deciding whether or not to opt for mediation and to inform them how to prepare for it. My next point relates to the changing landscape on mediation rules. And we have heard before that mediation as a tool in ISDS disputes has changed, and different rules have been developed by the International Chamber of Commerce, the International Bar Association, the Energy Charter Conference, the ICSID, and UNCITRAL. And it is my point that without formal training and capacity building of stakeholders in that area, it is unlikely that states will be willing to resort to mediation as a means of settling investor-state disputes. It is only with training of government officials and those who negotiate treaties that mediation is likely to emerge as a real alternative to arbitration or as a method of dispute resolution which can seamlessly be used alongside arbitration to resolve investor-state disputes. We have bilateral investment treaties which have mediation clauses, and the role of training of government officials can be used to renegotiate some of the clauses of these BITs. And what we can do in terms of encouraging state officials to negotiate these treaties would be to put forward some of the advantages of mediations, which include, but are not limited to, firstly, the cost effectiveness and time effectiveness of arbitration as a means of dispute resolution. It is also a tool from preventing disputes from emerging or escalating. And here, probably we have a cultural issue as well to deal with. States from the eastern part of the world, Hong Kong, China, India, and also some African states, they are more likely to prefer mediation than arbitration. Thirdly, in the event a formal dispute is triggered, mediation may assist parties to narrow down issues. Because if we use it in that way, it is probable that we can cut down the cost of arbitration if arbitration comes after we have narrowed down issues in mediation. And another advantage of mediation is it provides flexibility and autonomy to disputing parties. But without capacity building, without education in such areas, it is difficult to envisage states and state officials, as Charlie alluded to, going into this, because there would be mistrust, there would be concerns about corruptions. There will be concerns about opacity, accountability. I'll come back to that later also. I came across a very interesting citation in a case which pertains to arbitration in 2012, and that is the Achima against the Slovak Republic, Achima BV. It's a final award, number 60, December 7, 2012. And I thought I'd share that with you, where it is uncustomary in arbitration to refer to the need for mediation or the usefulness of mediation. And this is what we read from the agreement. And this is what the arbitrators said. The settlement on this case would be a good thing, in that the aims are approximately aligned, and that the black and white solution of a legal decision in which one wins and the other side loses is not the optimum outcome in this case. Should the parties desire to seek out somebody who might act as a mediator or reconciliator, the Secretary General of the PCA might be in a position to assist. I felt that this is quite significant because we don't have bigger than the PCA in terms of investment arbitration, and coming from the PCA, these are strong words indeed. And this shows the kind of dynamic situation in which we are right now. For a number of years, mediation has not been taken seriously. I think now there's a move to take it seriously. It's just a question of degree, what kind of role it will have in investor-state dispute. We are still in the early days, in my humble view. The next slide I have is in which context we can use mediation. Basically, it's the same as arbitration, changes in investment incentive measures, termination or interference of a contract by the state, revocation of license or permits, alleged breach of the fair and equitable provisions. These are standards, so I could see no difference between arbitration and mediation there. I think that both are equally applicable as means of dispute resolution. One interesting development, which I think might be a watershed event, is the Singapore Convention. And the Singapore Convention might actually trigger state practice. My own country, Mauritius, was one of the 46 signatories to the Singapore Convention. And this convention would apply to settlements in an ISDS context. However, I could foresee one difficulty there, and that relates to the reservation that the states could make. And if that reservation becomes the rule, I don't think we have much of a future for that convention. So a lot of work needs to be done there, because the reservation reads as follows. It says that a state shall not apply this convention to settlement agreements to which it is a party, or to which any governmental agencies or any person acting on behalf of a governmental agency is a party, to the extent specified in the declaration. So we really need to sell the usefulness of the Singapore Convention, and to encourage states to use it just as much as the New York Convention is being used, because at the end of the day, we can mediate agreements, but if they cannot be enforced, I don't think we are going to get anywhere in terms of progress. And in terms of the use of the Singapore Convention and capacity building, I think we are quite lucky that now UNCITRAL has started to work on this, and the ISDS reform process undertaken within UNCITRAL, in my view, has the capacity of fostering a culture through the creation of rules, or through capacity building through the advisory center, to just change how mediation is perceived among states. And that can significantly increase compliance with settlement agreements, and by avoiding expressing any reservations to the Singapore Convention. That would require a lot of marketing, a lot of hard work, a lot of capacity building. And in my view, not only at the level of state officials, because we have the political reality in all countries. You can convince government, but you also have to convince the opposition parties. because once you have a mediated agreement, that is going to be challenged nationally by local opposition, and we need to get their buy-in as well. Training in mediation is very, very important for state officials, because mediation as a means of dispute resolution must be mainstream amongst government officials. Right now, it's something that we talk about, but not many people are aware about it. And we need to make it internationally acceptable as a means of dispute in the ISDS context. If mediation is to be used as a means of dispute resolution which is effective, it is crucial to ensure that those who use mediation on behalf of the state are properly trained, that they use mediation effectively, and above all, are accountable. In that context, it is very useful that the IBA rules for investment state mediation, Appendix B, set out the qualifications as a mediator, and that shows that this is slightly different from arbitration. We need experience in dealing with government, you need experience as a mediator, you need mediation training, including accreditation by an internationally recognized organization. You need experience in any form of dispute resolution. You need also experience to deal with parties on the nationalities which are at stake, and that requires knowledge of different cultures. When we talk about capacity building, we need to remove barriers to the adoption of mediation as a means of resolving ISDS disputes. Many countries may not have legislative impediments to implement mediation nationally, but they will still be reluctant to go for mediation for at least the following reasons. They will need to prove to the citizens that they are acting in the best interests of the countries. The fact that it is easier for them to pay out money because there's a binding decision against them, against the state, instead of giving money out willingly after an obscure process. This was alluded to by Charlie early on. And also there's heightened confidentiality in the mediation process, because sometimes in arbitration, parties can agree to make the decision public. In mediation, the trend is we keep it confidential between the parties. So my view is, if we have to make mediation mainstream among the states, we have to ensure that there's accountability at parliamentary level, at state level, in relation to disputes which have been settled. And for this, we cannot look beyond training and capacity building. And then, if we train and we do capacity building, that will help to institutionalize mediation, and that will introduce a degree of internal monitoring and transparency in a process that normally is conducted under complete confidentiality. The advantage of that is this could help to facilitate settlements by reducing the chances of dilatory tactics, by bad faith party, and by alleviating the fear of allegations of corruption or alleviating fears of negative publicity. Furthermore, it is my view that integrating mediation through adjudicative process may serve to project it as an integral part of a reform ISDS. This will make it easier for states to accept responsibility for a proposed settlement rather than regarding such a move as an unacceptable concession. For this to happen in practice, we need to train state officials. We also need to train members of the opposition. We need to train NGOs who might have concerns about the way the state settles disputes. I shall skip the bit about cooling off period because panelists before me have already alluded to that. I'll move to the next one, which is UNCTAD mapping of international agreements and mediation. UNCTAD interestingly mapped 2,577 international investment agreements, which shows that not less than 627 treaties contain a provision for voluntary ADR. That would refer to conciliation mediation. There was no treaty containing a provision for compulsory ADR, and 1,813 treaties contain no provision and 2 treaties were inconclusive. So there's a lot of work, in my view, here in terms of treaty renegotiation, which can be done. Then again, that's another big debate. How far do countries want to push towards renegotiating their BITs? How far do investors are willing to engage in that process? That is quite complicated, in my view. The role of training and capacity building in the promotion of investor-state mediation practice. I think it is important to highlight that training can assist in overcoming the barrier on the part of government officials and investors in using mediation as a means of settlement of ISDS disputes. Because investors are another important side of the coin. I mean, we might trade government officials, but if investors do not trust that mechanism, we are not going to get anywhere. We can use training to educate government officials on the use of mediation alongside arbitration in the context of ISDS disputes. We can train government officials to ensure that they can develop model treaty clauses based on mediation and mediation protocols. And we can train government officials to ensure that bilateral investment treaties are negotiated so that these treaties can be used to allow for mediation. Quick quote from Anthony Clark. I think it's a cliche that he was the master of the rolls in the UK, and I'll just summarize what he said. He says that it is, of course, a cliche that you can take a horse to water, but whoever drinks is another thing entirely. This is a cliche. This applies very much to mediation. So we should be doing more to encourage states and litigants to use mediation to settle their international disputes on investment. The more we do it, the more likely they are to settle the disputes that way. But there's a lot of hard work to do before we reach a stage. And then, how difficult is the task ahead? I can do no better than quote American practitioner Arthur Mayer, who noted that the task of a mediator is not an easy one. The sea that he says is only roughly charted, and its changing contours are not clearly discernible. He has no science of navigation, no fun inherited from the experience of others. He's a solitary artist, recognizing at most a few guiding stars and depending on his personal powers of divination. This is where we are, in my view, at the moment. I mean, we have Anna here, who's an authority in sommité or on arbitrage. I mean, I would struggle to think right now who are the sommités on mediation. I can think of Frauke Nietzsche from the ICSID. I can think of TK, Alexandro, but this is the young generation. I mean, we need time to create academic articles. We need time to create a practice. We need time to create consistent rules. We need acceptance of that means of dispute resolution, and that would require a change in mindset from government, a change in mindset from investors, and there's a lot of education and capacity building that has to be done before we reach there. Conclusion, use of mediation in ISDS disputes, in my view, requires a paradigm shift. It is up to states and investors to decide how useful and cost-effective mediation is to them. There's a need to develop and publish guidelines on the use of mediation in the ISDS context. There's a paucity, in my view, of literature, academic literature, on the use of ISDS in the ICSID context, and more academic literature would certainly contribute in making mediation more acceptable to states, because when politicians have to defend it, it would be useful to them to refer to renowned academics, to renowned practitioners. Then they can use mediation as a means which is internationally accepted to settle disputes. And then we have to know that beyond the usefulness and cost effectiveness of mediation, it is important to ensure that there are transparent rules for mediation, and that as many countries as possible are party to the Singapore Convention, and as many countries as possible do not express reservations. Without training and capacity building in the use of mediation in the context of ISDS disputes, my view is that its use is likely to remain limited on its own. It can be used as an adjunct to arbitration right now. Maybe I'm not so optimistic about it right now. I think we have started the work, and I think more work is needed. I hasten to say that my views, I'm a law officer from the AG's office. The views expressed in this presentation are mine only and do not bind my office or the public operations. Thank you very much for your attention.
Thank you very much for this, Diné, for this very comprehensive presentation where you have attempted at responding to each of the challenges that you have identified by making the case for the need of capacity building. And that's very true. Capacity building at very different levels. Some of your points, like, you need to educate everybody in the government, but also beyond the government and even NGOs. So I think your mapping of all the capacity building efforts where they could be targeted at is really very good. I also noted the point that has recurrently come up in this entire day, which is this allegation, this fear of allegation of corruption, and the problem of the how mediation can fit into the need of transparency. That is really key in investment arbitration, because public funds are at stake, and then public measures are at stake. I think one of the interesting points of response here is that there is a lot of negotiation and discontinuation of cases taking place. If you look at the ICSID statistics that the ICSID Secretariat puts forward every year, you see that have about 35, 39, sometimes more cases that settle. And nobody knows why they settle, how they settle. And I still think that being in a process like in a mediation is a good protection for the government officials that are involved, a far better protection than a negotiation, which may have the outcome of discontinuing the case, but which is, I would say, even more opaque than if you go through a mediation process, where at least you know what is being done, what are the different stages, and why you do not need to be inside the caucus room. The outcome is going to the fact that the mediation is taking place, and the outcome of this mediation can remain publicly available. So I think there is something to be investigated at that level. So we have, as usual, very little time for our question and answers, but this is only one of the many exercises that we will be carrying through in Working Group 3 before we manage to have a fully developed reform option on investor-state mediation. But I don't want to let you go without at least addressing some of the questions we have. We have a first question that relates, I would say, more to the Working Group 3 process than to the discussion on mediation as a reform option. So if this is agreeable to Adrian Lai, who is putting this question, maybe we can skip it and keep it for the member states of Working Group 3 to answer through their engagement in the forthcoming weeks and months on what can be done to keep the momentum going in spite of all the difficulties we're facing. I'm also tempted to suggest that Nadia's question about the Energy Charter Treaty and Kazakhstan and the approach by the Kazakh authorities to European and American court decisions is maybe a bit far from our mediation topic here. So I would suggest that maybe she takes it up with Alejandro outside of this webinar. And I would like to just put one or two questions here. There is one about concrete measures that each of the panelists think that Working Group 3 should undertake to further the role of mediation and conciliation in ISDS. There is a very interesting set of comments which are more of observations from her experience from Jane Hu. And there is a question for Dinai on how do you have any suggestions on what can be done to further strengthen capacity building? So could we maybe start with Charlie, if you would agree to take the first question, which is the role of Working Group 3 to continue to promote or push, or what concrete measures could be taken to further or increase the role of mediation and conciliation in ISDS. I will then give the floor to Alejandro to maybe react to the comments by Jane Hu, and Dinai, you have a very clear question directed to you. So Charlie, you have the floor.
Thank you very much, Anna. Thank you for the question also. It's a very good question. And I think the answer for me to that is that Working Group 3, the wonderful thing about Working Group 3 is that it has so many states there. And for me, from the most important, well, the most significant impediment to states using mediation is actually the normalization of the process for themselves. So in that sense, Working Group 3 could normalize the process for states, make it a normal process for many states, in the same way that arbitration wasn't once a normal process for many people, and now it is the go-to process. So there is a lot of time actually in between. It links to the first question which was posed. There's a lot of time between the sessions, and I think if we can get the papers rolling out, whatever that might be, I think that will help, as long as there is concrete work and paper rolling out of Working Group 3 continuously. I think that's the key to success. And once that's rolled out, people use it, be it guidelines or whatever, people use it, people refer to it. And once it's normalized, I think it links also to the question below, in that once it's normalized, the internal structures of states and the legislation of states will provide for officials to use that channel more and more. So I think that's the way forward. Thank you, Anna.
Thank you very much, Charlie. Yes, you're very right on that. Alejandro, some views to exchange with our colleague and friend Jane Hu.
Yeah, thanks, Anna. So I do agree. It's important, as mentioned before, not only to raise awareness, but to make sure that the mechanism will be there at outside means of the institutions and the rules, but also internally. And that's even more important, to make sure, as Jane mentioned in the question comments, that there is an internal framework letting the officials know to what extent they can get involved, who they have to ask for, and how to proceed, steps, timeline, what are the limitations. And that will make them feel confident that they can actually go to mediation as an option without risking or without being afraid of potential later responsibility, liability, or potential allegations. And I think this is key. It's something that the NSC Secretariat has been helping several countries to find out what will fit better for that particular country, because of course there is not one size fits everyone. But important is to start writing or building on what is important for you and have a first step.
Thank you very much indeed. And I think there is a wealth of experience and contributions that the Energy Charter Treaty Secretariat can make. And we are very, very much looking forward to your increased participation. I know that you're already involved in our Working Group 3 as an observer, but together with ICSID and other institutions that are hands-on, I think it's really important that you continue to contribute. So thank you for that in advance. Dinai?
In terms of what can be done in terms of training and capacity building, I think academia, in my view, plays a very, very important role, because academics are independent. Academics have academic freedom when they have to criticize practices from powerful states or from influential states. They would not be very limited in their criticism. So I think academia has a big, big role to play in terms of producing write-ups and journal articles on the use of mediation, and also by chartering the waters, that is setting out the advantages, the context, the disadvantages, and educating people about it. I think this is the start. And then UNCTAD can provide online courses, in my view, and this is a cheap way of getting, relatively cheap way of getting people trained up, especially in the midst of the current pandemic, where travel is not possible. It's difficult to access campus and all. So I think UNCTAD can do some effective work there. I think Working Group 3 is already doing a lot of work with the wealth of literature that is being provided, and the more that literature is disseminated to the largest number of states as possible, and not only disseminated, but provided that people read it. So state officials and other people must actually read what is being done in Working Group 3 to ensure that they are kept abreast of latest development. And then we have things like we are doing today, that is institutions like AIL can make mediation more visible to actors, to states, to investors, and also training centers such as the Center for Effective Dispute Resolution in the UK, CEDAR, which have considerable experience in mediation. And in Hong Kong, they even have a mediation local law. They have a wealth of experts. DOJ of Hong Kong can, through MOUs, maybe with less advanced countries or less countries which are less knowledgeable in arbitration, can share their wealth of experience with third countries. These are my preliminary views on the matter. Thank you.
Thank you very much, Dinai. This is quite a menu we have in front of us, and lots of synergies, which is important, because we only have that much resources at everybody's level, or every organization that is involved there. So pooling resources is definitely the way forward. So with that, I would like to thank our panelists for this concluding session. A lot of food for thought for Working Group 3. I'm sure that many colleagues have been taking notes, and we will be able to feed all this interesting discussion into the work of Working Group 3. Thank you very much. And I wish I could applaud virtually. It doesn't work. It doesn't make for a nice ovation, but still, you have my grateful thanks. And now I'm giving the floor back to the organizers for our last and concluding session. I thank you very much.
That's the end of session 4. To conclude this meeting, Ms. Theresa Cheng, GBS SC JP, will deliver the closing remarks. Ms. Cheng is the Secretary for Justice of the Hong Kong Special Administrative Region of the People's Republic of China. It is with great pleasure that we would now invite Ms. Theresa Cheng, GBS SCJP, to deliver her closing remarks.
Good afternoon, good evening, or perhaps even good night to some parts of the world, and perhaps good morning to some of you as well. Welcome and thank you very much for participating in this pre-intersessional meeting. The Hong Kong Special Administrative Region is most honored to have the opportunity to co-organize with UNCITRAL and the Asian Academy of International Law today's pre-intersessional meeting for Working Group 3 to contribute to the discussion on the use of mediation in ISDS. This virtual pre-intersessional meeting, a first of its kind, is our featured event this year, following our flagship Hong Kong Legal Week and the annual mediation lecture we had last week. We would like to especially thank the Central People's Government and UNCITRAL for supporting today's pre-intersessional meeting. This is in fact the first time for the Hong Kong SAR to organize an event for a working group of UNCITRAL. This indeed reflects our innovative aspect of one country, two systems, and the basic law in which representatives of the Hong Kong SAR participate in the work of UNCITRAL as members of the Chinese delegation. As I have previously discussed in the Chartered Institute of Arbitrators Alexander Lecture entitled The Search for Order Within Chaos in the Evolution of ISDS, development of mediation is one of the two strands of the double helix approach to the evolution of ISDS. We are pleased to see that the greater use of mediation is a reform option that has attracted much interest and support among delegations of Working Group 3, especially in its 39th section recently held in October. Different interesting ideas and suggestions have been expressed by various national and observer delegations in developing investment mediation. The task at hand is how to ride on the momentum and synthesize these ideas and suggestions into a set of comprehensive and practical ISDS reform solution on mediation. Much has been said on the benefits of investment mediation. Evidently, it provides a flexible and voluntary dispute resolution mechanism that allows foreign investors and host jurisdictions to resolve their investment disputes through creative and forward-looking settlement arrangements and preserve their long-term relationships. Various structural and policy impediments to the greater use of mediation in ISDS nonetheless exist. Various studies and the experience of speakers suggest that as compared with investors, governments may face some unique challenges, such as a lack of familiarity with mediation and the use of a facilitative framework at the domestic and treaty levels for the use of mediation. In the panel session, we have heard the experience of a broad spectrum of actors in the areas of ISDS, ranging from international organization, government official, practitioners to academics, in seeking to overcome challenges to the use of mediation in ISDS. The range of options are diverse, which may even include an opt-in style multilateral instrument. At a bilateral level, one must not forget the possibility of pre-dispute and post-dispute agreement to mediate. In the case of CEPA investment agreement between mainland China and Hong Kong, a pre-dispute mediation clause provides for dispute resolution. Given that mediation is entirely consensual, with enough knowledge, parties may still be able to opt in to use mediation even after the arising of the dispute. Panel Session 2 and Section 3 can perhaps be best viewed together. On the process design of a multi-tiered or hybrid dispute resolution mechanism, as explored in the panel sessions, there is no limit to creativity. Mediation can be used alone or combined with arbitration to form a multi-tiered dispute resolution process. One example is the mediation first, arbitration next model that Hong Kong adopts in Financial Dispute Resolution Center and the recent COVID-19 online dispute resolution scheme of eBRAM. As discussed in Ronald's presentation, the CEPA investment mediation rules may be a suitable model for the working group to look at in developing a set of protocol that can be incorporated into international investment agreements. The idea for a permanent investment court to foster mediation is also a possibility. The permanent investment court would entail a radical revolution of the ISDS system, and the desirability of such revolution, as opposed to a natural evolution of ISDS, is probably a matter to be better discussed and carefully examined on another day. In any event, today's discussion illustrates that mediation is a mechanism that works well in any setting, whether in multi-tiered or hybrid dispute resolution mechanisms. There is a lot of food for thought, as there is in fact an infinite number of ways to tailor-make a process using mediation as an essential ingredient. I tend to think that catering for a number of set of rules of the multiple iterations may not be all that practical, and perhaps a mediation protocol or a protocol for a multi-tiered or hybrid process may be the way to go. Ideally, mediation protocol should enshrine values of rule of law and sets out a basic and highly customizable framework that can be adapted by the disputing parties, adapted to the disputing parties' preference and the nature of the particular disputes. Such mediation protocol should also place strong emphasis on cost efficiency and adhere to the principle of voluntary participation. In the context of investment mediation, the protocol will also need to strike the right balance between transparency and confidentiality. In panel session 4, looking at the way forward, the summary that is set out in that session for mediation as an ISDS reform option seems to be focused on 3 main directions: getting the frameworks right, overcoming psychological barriers through education, and unlocking mediation's synergy with other ISDS reform options. Getting the frameworks right is essential for empowering, incentivizing, regulating, and facilitating the use of mediation by government officials and investors in resolving ISDS disputes. There are 2 dimensions to such frameworks, one being the treaty level and another being the domestic level. At the treaty level, it is mainly concerned with the development of model treaty clauses on mediation and investment mediation protocols for international investment agreements to provide a roadmap to guide the disputing parties in their use of mediation. At the domestic level, we have heard the useful sharing by Alejandro on the model instrument on management of investment disputes developed by the Energy Charter Secretariat, which sheds light on how governments may establish or refine their domestic institutional frameworks to facilitate, amongst others, the use of mediation for resolving ISDS disputes. To overcome the psychological barriers for disputing parties over the use of mediation in ISDS, education, education, education is the very key, and the target audiences must include government officials. Since 2018, the Department of Justice has partnered up with leading institutions such as AAIL, ICSID, International Energy Charter to offer its flagship investment law and investor state mediator training courses. The 2 rounds of courses were attended by over 90 participants from over 26 countries around the world, including government officials, as well as legal and mediation practitioners. We are indeed pleased to have one of our alumni, Mr. Diney, joining us today to speak on the subject of mediation and share his experience on putting mediation into practice in his work for the Mauritius government after completing the course. The Department of Justice will continue to offer capacity building courses on investment mediation in the near future, with the next round to be held in 2021. Apart from mediation, Working Group 3 is looking at various other ISDS reform options. Given the inherent nature of mediation as a flexible mechanism, one can see that there is room for exploring potential synergy of mediation with other reform options, such as ISDS appellate mechanism, dispute prevention mechanisms, as well as the establishment of an advisory center on international investment law, as discussed in Charlie's presentation. Following today's pre-intersessional meeting, probably there are a lot of ideas on the plate for the UNCITRAL Secretariat with respect to what the working group may work on with respect to mediation. Having good ideas on papers is, however, not enough. And it is also crucial to consider how the working group can practically achieve progress in its work on mediation within a reasonable period of time, especially when the working group does have a wide range of ISDS reform issues to tackle. During the 39th session on Working Group 3, the Chinese delegation mentioned the possibility for the working group to resort to other constructive, inclusive, and transparent working methods to develop the work on mediation, in addition to its formal sessions. As a preliminary idea, the use of informal drafting groups or experts groups may be an option worth being considered, especially for developing the texts on model treaty clauses and investment mediation protocols, as well as the relevant guidelines. Informal drafting groups or expert groups are tools that have previously been utilized in UNCITRAL processes. Such informal groups allows different stakeholders to draw on their best practices, experience, and knowledge to collaborate in crafting the work on investment mediation for consideration by Working Group 3. Given the support enjoyed by mediation in the working group, the use of drafting groups or expert groups can expedite the work on mediation while sticking with the work mode of Working Group 3, where no decision of working group will be made outside its formal sessions. We hope that today's pre-intersessional meeting manages to facilitate Working Group 3 in its consideration on how to further unlock the potential of mediation in ISDS reform option. To contribute to the process of Working Group 3, the insights in today's discussion and the background papers prepared by the various practitioners from Hong Kong will be crystallized into a proceedings, which we hope will subsequently be made available to the working group. While we cannot meet in person today due to COVID-19 pandemic, we are pleased to report that the use of technology allows us to make this event accessible live online and reached out to 74 countries or regions with around 530 registrations. In this relation, it is also worth mentioning that Hong Kong actively supports the greater use of technology in international trade, and the Department of Justice Project Office for collaboration with the UNCITRAL has officially opened in the Hong Kong Legal Hub to work on this area. Hopefully, the world will soon recover from the pandemic. We look forward to welcoming you all in person here in Hong Kong at the next intersession meeting in 2021. Thank you very much.
Once again, thank you very much for joining us today at the UNCITRAL Working Group 3 virtual pre-intersessional meeting on the use of mediation in ISDS. This meeting is now adjourned. Thank you.